Good morning and welcome, everyone. On this Tuesday, June 6, 2023, I called to order the Kansas Corporation Commission business meeting. I'm Susan Duffy. I'm serving as the chair of the commission, and I'm joined by Commissioner French and Commissioner Keene. On today's agenda, we have 46 consent items and 6 noticed items. Commissioners, you've had the opportunity to review the consent agenda. Are there any questions or comments? And I'll start with Commissioner French.
No questions, thank you.
And Commissioner Keene?
No questions. I move approval of the consent agenda.
Second.
There is a motion and a second to approve the consent agenda. All those in favor, please vote aye.
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 Aye. Motion passes. Thank you. Our second item is docket number 19 GBEE 253 ACQ in the matter of the joint application of Invenergy Transmission LLC, Invenergy Investment Company LLC, Clean Line Energy Partners LLC, Grain Belt Express Clean Line LLC, and Grain Belt Express Holding LLC for an order approving the acquisition by Invenergy Transmission LLC of Grain Belt Express Clean Line LLC. This is an order granting motion to amend the unanimous settlement agreement, and our presenter today is Mr. Brian Fedotin. Good morning, Mr. Fedotin.
Good morning, Commissioners. The Grain Belt Express Clean Line project is an approximately 780-mile transmission line that connects over 4,000 megawatts of wind power in western Kansas to customers in Missouri, Illinois, Indiana, and states farther east. On June 18th, 2019, the Commission issued an order approving the unanimous settlement agreement, finding it was in the public interest. On March 10th, 2023, Grain Belt Express LLC filed a motion to amend the unanimous settlement agreement to amend the financing requirement to allow benefits to accrue in Kansas sooner. Currently, paragraph 9.9A of the settlement agreement bars Grain Belt from installing transmission facilities on easement property in Kansas until it has obtained commitments for funding to build the entirety of the project. Now, Grain Belt plans to construct the project in 2 phases, with Kansas being in the first phase, and thus it wants to modify the financing requirement to allow it to install the transmission facilities in Kansas as soon as it obtains financing commitments for phase 1 of the project. On April 23rd, Commission staff filed its report and recommendation recommending approval of the motion to amend the unanimous settlement agreement. Staff's R&R agrees with Grain Belt that the proposed amendment would not reduce the existing protections to Kansas landowners or the public, and also that the project would benefit Kansas. Staff's R&R states its belief that it is likely that constructing the project in 2 phases will bring benefits to Kansas sooner than constructing the project in just 1 phase. This order finds that amending paragraph 9A of the unanimous settlement is in the public interest. And therefore, this order would grant the motion to amend the unanimous settlement. With that, I'm available for questions.
Thank you. Are there any questions? Commissioner French?
No questions.
And Commissioner Keene, questions or comments?
One question for you, Brian. Explain just a little bit, if you could, for the record here, the 2 different phases that we're talking about here with respect to this plan. Instead of doing it in one fell swoop, the plan is now to do Kansas first and then the other states that are affected by the line after that. Is that what you're saying?
Basically, Kansas and Missouri would be in phase 1. Indiana,
Brian, you're breaking up and you are frozen. Maybe if you turn off your video.
Illinois.
Brian, you're not coming
Been
through.
some delay
Could
in chiefly Illinois.
We cannot hear you, Brian. Can you turn off your video?
Sorry.
I see you, Brian, but I don't see anybody else now.
Yeah,
I think they're working on it.
yeah. I guess it didn't like my answer.
We didn't hear your answer. It broke up immediately.
Okay, looks like we're all coming back. We're missing Commissioner French. Probably where we'll start, Brian, is you answering Commissioner Keen's
Sure.
question.
Sure.
Okay, all right. It must be our Wi-Fi here. All right. We are back on the record with that technical difficulty. Where we were, Commissioner Keen had asked a question and Council Brian Fedotin was in the process of answering. So if you would, please.
Sure. Thank you. In paragraph 7 of our order addresses your question. Phase 1 starts in Ford County, Kansas, and goes into Missouri. Phase 2 would begin in Monroe County, Missouri, and go to the Illinois border. The Grain Belt is targeting to begin construction of phase 1 near the end of 2024 and starting construction on phase 2 18 months to 2 years after it completes after phase 1.
So am I correct in understanding that the regulatory approvals for all of these states have been obtained?
I believe so, yes.
And I know there was a question about eminent domain issues in Missouri. Has that been resolved? I'm not trying to ask you to know all or be all about these matters.
I want to be a little careful because I don't remember what's public and what's confidential in terms of the status. We've been getting compliance reports, and I can't remember. So I don't want to inadvertently say something confidential in this forum.
Okay. I guess my reason for asking it, I'll at least have that clear for the record, is because that it would seem to me that the totality of the line encompasses several states,
Right.
and what good would it do to do phase 1 if phase 2 couldn't be completed for whatever reason? That's
Sure.
what my concern is, and the protections that need to be afforded to Kansas landowners in the process.
No, I understand that, and there's confidence on all parties that the entire line is going to get built. I just don't know the what is confidential and what is public without further review on the status of some of the individual parcels of land in Missouri and Illinois.
All right, well, I appreciate that. I wasn't trying to mousetrap you with these questions, by the way.
I mean, the commission has been, and its staff has been fully informed, but with quarterly confidential and public updates on the status of the line, the number of easements, the status of the easements, the eminent domain proceedings. And so we are confident that the entire line is going to be built. I just don't know to what level the details can be discussed in public.
But it's possible that I'm the only one among the three of us that really is having these concerns. I guess I would prefer, if we could, to and I would so move that we defer consideration of this matter for a week. Do you see any problem with that?
I don't think a week would change any construction timelines or anything like that.
No, but it will change my ability to maybe become more informed about the details I think are important.
That's fine. I mean, assuming, yeah, I have no objection. I also don't have a vote, so I don't want to make it sound like I'm casting a vote that I don't possess.
Okay, so Commissioner French, would you like to make any comments at this point?
No, and I have, as long as there's no statutory deadline issues from Mr. Fedotin, I have no issue with passing over this and considering it at the next meeting.
So it appears that what we will do at this point on docket number 19 GBEE 253 ACQ, it's a noticed item, and it appears that it is the will of the body that we pass over this item and place it back on the agenda for June 13th with hopes that all questions are answered by staff. Is that what I'm hearing from everyone?
That's certainly where I'm coming from.
Okay, so
and accordingly, I would withdraw my motion, given the fact we're passing over it.
okay, we will pass over this item and place it on the agenda for next week on June 13th. All right, very
Thank
good.
you.
All right. Commissioners, we will go to the second noticed item, docket 23 EKCE 588 TAR, and the matter of the joint application of Evergy Kansas Central Inc., Evergy Kansas South Inc., and Evergy Metro Inc. for approval of tariff changes related to wholesale demand response participation. And this is an order on Voltus Inc.'s motion for leave to depose Evergy witness. Again, our presenter is Mr. Brian Fedotin.
Yes, thank you. On May 12th, Voltus filed a motion for leave to depose Evergy witnesses and a motion for expedited treatment of an order to that effect. Voltus explained that Evergy was not fully responsive to certain data requests, which they argue warrants deposing Evergy's personnel. Evergy opposes the motion to depose its employees. Voltus filed a reply claiming depositions are necessary in the absence of a hearing. They have no opportunity to cross-examine witnesses. When the commission granted Voltus intervention and denied its motion to delay issuance of a procedural schedule, the commission's order stated that, quote, "At this time, the commission believes an evidentiary hearing is unnecessary. However, if circumstances change and the commission finds it necessary to conduct a hearing, it can extend the schedule by up to 60 days to accommodate a hearing. For now, the commission believes scheduling an evidentiary hearing is premature," end of quote. In this order, the commission determined that it's appropriate to schedule a one-day evidentiary hearing and directs the parties to propose a procedural schedule that includes a one-day evidentiary hearing. The commission does not believe Voltus has demonstrated a need to take depositions, and since we are directing the parties to propose a new procedural schedule that includes an evidentiary hearing, Voltus's rationale for depositions is moot. So this order denies the motion for leave to depose Evergy witnesses, but directs the parties to propose a new schedule that includes a one-day evidentiary hearing. With that, I'm available for questions.
Thank you. Starting with Commissioner French, do you have questions or comments?
No questions.
And Commissioner Keen?
No questions. I move approval of the order.
Second.
There is a motion and a second to approve the order. All those in favor, please vote aye.
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 Aye, the motion passes. Thank you. Our next item is docket number 23 EKME 843 COM in the matter of the complaint against Evergy by Kyle Wayne Morey. This is an order on prima facie determination. And again, our presenter is Mr. Brian Fedotin.
Yes, thank you. On May 25th, Kyle Wayne Morey submitted a formal complaint against Evergy, claiming Evergy has failed to resolve issues related to a power line easement. Upon review, the formal complaint does not comply with the requirements of KAR 82-1-220B and therefore fails to establish a prima facie case for commission actions. The formal complaint lists Mr. Morey's address as Lamar, Missouri. Based on the complaint, it's unclear whether the easement is on property in Kansas. Likewise, it's unclear whether the complainant is an Evergy customer or if Evergy has any property interest in the transmission line, which is unidentified, or the power line, I guess. Pursuant to KAR 82-1-220C, the complainant is given 30 days from today to correct the deficiencies that I just described. With that, I'm available for questions.
Thank you. Commissioner Keen, do you have questions or comments?
No questions. Thank you.
And Commissioner French?
No questions. I move approval of the order as described.
Second.
There's a motion and a second to approve the order. All those in favor, please vote aye.
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 Aye, the motion passes. Thank you. Our fourth item is in the matter of the failure of BHD Resources LLC to comply with KAR 82-3-120 and KAR 82-3-133 by operating wells that are not under its license. This is a penalty order, and our presenter today is litigation counsel, Mr. Kelsey Marsh. Good morning.
Good morning, Chair Duffy, and thank you, Commissioners. Before you is a penalty order for BHD Resources LLC, which was found to be operating wells which are not on its license, but are instead under the suspended and revoked license of Haas Petroleum, Inc. The order assesses a $10,000 penalty. With that, I would recommend approval of the order, and I am available for any questions.
Thank you. Commissioner French, do you have questions or comments?
No questions. Thank you.
And Commissioner Keen?
No questions. Thank you. I move approval of the order.
Second.
There's a motion and a second to approve the order. All those in favor, please vote aye.
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 Aye, the motion passes. Thank you. Our fifth matter is in the, docket number 23 CONS 3344 CPEN in the matter of the failure of Champ Petroleum LLC to comply with KAR 82-3-120 and KAR 82-3-133 by operating wells that are not under its license. This is a penalty order, and again, our presenter is Mr. Kelsey Marsh.
Thank you. Before you is a penalty order for Champ Petroleum LLC, which was found to be operating wells which are not on its license, but are instead under the suspended and revoked license of Haas Petroleum, Inc. The order assesses a $10,000 penalty. With that, I would recommend approval of the order, and I am available for any questions.
Thank you. Commissioner French, questions or comments?
No questions.
And Commissioner Keen?
A couple of questions, Kelsey. Again, I'm not trying to mousetrap you either here. Here we have this docket plus the one we just considered are two entities that appear to be related somehow to Haas. Are there more than these two that the staff is aware of, you know?
At this point, these are the only two that staff is aware of, any connection between these current operators and Haas Petroleum Inc.
And am I correct in, I have read the order, but am I correct in concluding from your summary that the issue that's involved in this docket is virtually identical to the issue involved in the prior docket we just considered?
I would say that's correct. I think the issues in both of these dockets are practically identical.
Okay. Were T1s filed here at all?
They were, BHD Resources filed, or T1s were filed for the leases on BHD Resources, or associated with BHD Resources, I believe on February 3rd of 2023. T1s for sending the two leases from Haas to Chant were filed on, I don't have the exact date, but it was in July of 2022.
Okay. All right. That's the end of my questions. I appreciate your responses very much. I would move approval of the order.
There is a motion.
Second.
I'm sorry. There's a motion and a second to approve the order. All those in favor, please vote aye.
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 Aye, the motion passes. And our last item is in the docket number 23 CONS 3345 CPEN. And it is in the matter of the failure of Haas Petroleum LLC to comply with KAR 82-3-120 and KAR 82-3-133 by operating under a suspended and revoked license. This is a shut-in order, and our presenter again is litigation counsel Kelsey Marsh.
Thank you. Before you is a shut-in order for Haas Petroleum LLC. The order assesses a $50,000 penalty and directs staff to shut in Haas Petroleum's wells until it complies with the commission's penalty orders and dockets 21-3193, 21-3201, 22-3031, and 22-3034, and its operator's license is reinstated. With that, I would recommend approval of the order, and I am available for any questions.
Thank you, Mr. Marsh. I'll turn to Commissioner French. Do you have questions or comments?
No questions.
And Commissioner Keen?
Thank you, Chair Duffy. One question again for you, Kelsey, in this particular case. And am I taking to understand here that I think you alluded to 3 prior dockets as the source of the penalties that this penalty alleges are in violation of, if I've stated that correctly. Are those 3 previous dockets the ones that were subject to the evidentiary hearing that we had several months ago?
Yes, the dockets that were the cause of the suspension that led to the shut-in order were the dockets that were at issue at that December hearing.
And then can you get, and that was a December hearing that the commission had, right? And so subsequent to that, the staff, upon inspection, field inspection, has found that there is operation in violation of that order. That gives rise to this order. Is that correct?
Correct. And I think I said December. It may have been in October. It was a while ago, but it was towards the end of October or end of 2022. And then the commission issued its final order, which I think became effective in February of this year. Or the suspension became effective in February this year for non-compliance with those dockets, which led to the suspension or shut-in order.
Okay. And there was no request for reconsideration, I presume?
There was, I think the reconsideration was filed in November or December of 2022. I can't remember if the commission denied it or not, but I remember that there's some filings mixed in there at the beginning of 2023, and that the order basically became final / effective or any production or operation found after that February 6th, 2023 date could result in a shut-in order being issued by the commission.
Timely filing for judicial review, I presume.
I do not believe there's any filing for judicial review.
Okay, last question. Do you know roughly, or do you know precisely when did what were the dates of the staff follow-up inspections in the field?
1 second, please. It looks like the staff's follow-up inspections were on March 24th, 2023.
I guess I know this assesses a pretty stiff penalty. We've got a $50,000 fine under this order, plus shut-in order, which is kind of in terms of field action, it's kind of the ultimate activity that we can engage in cases of violation. I'm not concerned about either one of these penalties. Maybe slightly concerned about whether the monetary penalty is adequate under the circumstances. I will move for approval of the order, and I would be certainly open to any comment about the adequacy of the penalty from my fellow commissioners.
I'll second the motion.
Okay, do you have any comments about the monetary penalty, Commissioner French?
No, although I would subscribe to some of the observations made by Commissioner Keen, but I will second the motion.
Okay, we have a motion and a second to approve. I will put in my comments. This has been a lengthy process, and Mr. Marsh, can you just tell us when the operators went back and did their follow-up field inspection, what did they find?
Whenever staff conducted its follow-up field inspection in March, they found the wells that are listed in the penalty order being operated by the two other companies that were at issue this morning, BHD Resources or Champ Petroleum. So since those wells are in operation, they were still under the revoked and suspended license of Haas Petroleum. Staff felt it appropriate to seek another monetary penalty and a shut-in order.
And while this penalty is $50,000, there have been other penalties levied against this company, correct?
Correct. Before this penalty was issued, I believe there was a total of about $158,800 worth of fines assessed against the operator. To my knowledge, none of those fines have been paid at this point in time.
So all of those fines are still due and owed to the commission, correct?
Correct. And I don't know if we've sent them to set off yet or not. I'd have to check with my administrative assistant, but those fines have not been paid. They would need to be paid before the operator could apply or try to obtain a license again.
And you are not aware of the operator ever contacting you to make any sort of payment arrangements on those prior obligations, correct?
Not since the final order was issued by the commission.
Okay. My comment, I understand your frustration, Commissioner Keen, because apparently the substantial penalties that we have levied before has been inconsequential as this operator has continued to operate in clear violation. And I'm hoping that we are able to collect on the debts that are owed. These are fines for penalties incurred that every operator who finds himself on that side must pay. If not, pay us directly through the set-off program or whatever else is available to the state of Kansas to collect those fines. However, I do understand the frustration, but I will put this up for a vote. All those in favor,
If I may have a comment,
go ahead.
Chair Duffy, but pardon me, Chair. I'm sorry to do that. I do have a follow-up comment and a question, given
Okay.
your comments. I think the points that you're making are well taken. The fact that we have a shut-in order, of the nature of what shut-in orders are, should put an end to this, I would think, with respect to the wells that are subject to this order. But the follow-up question I would have for you, and again, I'm not trying to mousetrap you here, Kelsey, you may not know the answer to this question. Do you know, in the period intervening between the time of all the process since the commission order was issued and the reconsideration period has expired and all the rest of that, do you know if they've sold any production? I mean, they were obviously producing or trying to. Do you know if there were any sales?
I am unaware of any sales that have been made since the final order was issued. I don't know if the two operators that were found to be operating these leases sold any oil. Unfortunately, I don't know if those records would be available yet on KGS or not, since it takes 4 to 5 months usually for those records to be updated.
Usually about 3.
Yeah.
Okay. All right. Very well. Thank you. I have no further comments. Thank you, Chair Duffy.
Yes. And the shut-in order presumably is the last step here. So we have a motion. We have a second. All those in favor, please vote aye.
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 Aye. The motion passes. Thank you very much, Mr. Marsh.
Thank you.
Commissioners, this does conclude our agenda for the day. Are there any other items for the commission? If not, I will entertain a motion to adjourn.
So moved.
Second.
There's a motion and a second to adjourn. All those in favor, please vote aye.
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 Aye. The motion passes. Thank you. We are adjourned. Stay safe, everyone.
Take care.
Be well.